Good evening, Mr. Salva. Can you hear me?
Very good evening.
Yeah. Okay. Yes.
Ansaria, how are you doing?
Yeah. Good. Good.
I just finished an NCLT matter. I could not get time to change the item number.
Okay. Okay. Great.
Yes. So should we wait for the committee, Aor, or should we start now?
We'll wait for the registrar will come and then we'll start. I think
Right.
somebody from registrar we can unmute ourselves for the time being, and then once the registrar comes, we'll formally start the meeting and then we'll start it.
Yes.
I think maybe a problem. I think my name is coming wrong, so I'll just log out and log in again. Okay. Yeah. Okay. It did.
My learned sir, myself Tapan Sharma, learned Ansaria Sahab and learned Savla Sahab. I am Tapan Sharma, since your examination. Registrar sir will not be, there in this lecture series schedule. So, with the kind permission of the
Yes,
sir, please.
Yes, we can start. Yes.
Sir.
So I think candidates, most of them joined. They have.
Sir.
Can we start?
Sir.
Okay.
Yes, Vijay, I request you to start and then we'll continue.
Yeah.
Yes.
I think, Mr. Savla, you can change your. I also had that item number in between, so we can. Your display name is showing.
Okay, that's all right. I think that's it.
Yeah, I also did that just now.
Yes.
Okay, good evening, everyone. Welcome to the lecture series for the year 2024. I think this is the first lecture on the series of lectures you will be having from today onwards till 11th. And I wish you all the best. Say, today we are discussing the issue, paper 2, drafting. According to me, drafting, normally in the lecture, we say what to write. Let me start saying how to read. I have seen the earlier questions papers of last 4 or 5 years. Every question paper has a different pattern. And it a lengthy paper. Sometimes you have questions of 20 marks, 20, 30 marks, 4 questions, 5 questions, compulsory questions, optional questions. It can be anything. So you must, and that's why you are given half an hour extra for reading the question papers. Normally, we don't get that time. You don't get the time in any other paper except this paper. So this paper, and this is the most important work of an advocate on record. I myself was in advocate on record. My colleague have been advocate on record. So we have drafting is the most important work for an advocate on record. Even after passing this, the judges judge you by what you have written. Your clients will see what you have written. Seniors whom you go to brief will see how you have put it. So this is the paper which you have to concentrate, not only for passing out the examination, but for entire duration on which you will be an advocate on record. Now, while coming to reading, please be very, very careful what the examiners are asking you. Sometimes you are asked to draft complete SLP, which will start from index to cover paper, to synopsis, to list of dates, to the specially petition, to the affidavit, to the certificates. And sometimes you are asked only to draft synopsis and list of dates without affidavit. Be very, very clear. See, you make one mistake and then entire paper goes. There are sometimes sections, section 1, section 2. In section 1, you are required to answer 1 question. In section 2, you are required to answer 3 questions. But sometimes if you answer in section 1, both and question 1 and 2, you are gone. Examiner will only see 1. That's what I'm emphasizing on the reading of the question paper. And it takes half an hour to read, because I have been reading the earlier question papers. It are quite lengthy papers, and there is a reason behind it. See, you are going to be a advocate in record. It's a very, very important stepping stone in your career. For that purpose, you must see it very, very careful, because while as a senior counsel, also now we find that many SLPs are drafted without proper application of mind. And take it from me, if you don't read the brief carefully, you are not going to get marks in this examination at least. It will be very, very important for you. Now, coming to it, in the Supreme Court, we have 90% of our cases are SLP. Though we have writ petitions, though we have PIL, though we have transfer petitions, and so on and so forth. But 90% of the work, you all know, is the special leave petition. Please be very careful while drafting the special leave petition. And I do not know how many of you would know there is a prescribed format in the Supreme Court rules. That is Form 28, which is there as to how the special leave petition has to be formatted in draft. There is Order 21, especially Rule 3, which says special leave petition civil has to be in the format of Order 28. It also gives you further what all it should have. It should have a list of dates. It should have a synopsis. It should have a grounds. It should have questions of law. It must have a prayer, interim relief. So you must focus the question, understand the question carefully, and then answer it. Let me go step by step. What do you do in a special leave petition? You start with the cover page. Sometimes they may ask you that you do a cover page. Sometimes they don't ask you that you do a cover page, but you must know. Then you have an index. We have a very specified provided mechanism for an index. We have a very specific things for the synopsis. Synopsis, you summarize. I find in most of the cases, people sum up the facts in the synopsis, but synopsis is meant to be what is your focus, what is exactly your grievance against the High Court judgment. Then you give facts chronologically, and it must be very critical. And what all you want to annex, you must know what to annex. Especially, you must annex the original pleadings in a civil case. You must annex the relevant witnesses in the criminal case. So you must write as so and so a true copy, or whatever it is, a true translated copy is annexed with so and so. While drafting the annex list of dates, you must write that. Then comes the SLP. Then in the SLP you have para 1. Then you have separately in the SLP you have questions of law. Then there are certain certificates. Then you have grounds. Then main prayer. All these are in a format. Form 28. I have also not known it for so long a time, because these rules are 2013. By that time I ceased to be an advocate in record. But then this format is clearly given. So it must be in that format when you prepare the special leave petition. Similarly, and if you have any additional documents, any additional grounds, you are not supposed to write anything which is not there part of the court record below. Not annex any document which are part of the court record below. You must, and in case you find that you must have annex certain things or raise new grounds, you must tell the court that these are the new grounds, give justification why it should be there, make a separate application for that additional grounds if they are required. So all these are part of your drafting of an SLP. Similarly, in criminal SLP, there is a confusion of what is the criminal SLP format, but the rule says it is the same format. The rule Order 22 of the Supreme Court rules deals with criminal SLP, and it says it is the same format as Order 21 Rule 3, which is civil SLP. So be very clear that their criminal SLP, civil SLP would be in the same format. What is required to be said, you must, and don't repeat. Many times we find that if you think that you have written 20 pages and somebody has written 10 pages, you will get more marks. I'm sorry, this will not be correct understanding of the examiners. They will see, and we put a lot of effort in reading it. And while reading also, please be careful. Don't write any messy things. You write and we are supposed to read. Just think that, yes, examiners are also reading it. Must be very, very methodical. I've been examining various question answer kits, and sometimes I feel that I must not read. I'll return it without reading it, without giving any marks. Because see, while you are writing, it is writing not for you. It is writing that we read it. And this time we are starting the both the mechanism for online and handwritten and computerized. Slowly, I would encourage that you must do the typing version of it. Many of us doesn't start it, but you're all young people, you must start it. And there, the problem of the handwriting, etc., may not come. But otherwise, wherever the handwriting comes, you be very careful, be very methodical, be very systematic, give the headings, give the subheadings for the purpose of handwriting, for the purpose of on various paragraphs you have, various grounds you have, make it very, very clear. One is that you also are required to file certain times applications. Under what provision of law you are making applications? Is there any delay in filing the SLP? You must consider those aspects while you are preparing the SLP. See, when it comes to us, when it comes to you a brief, you calculate the limitation. Sometimes they may ask you what is the limitation. Sometimes you have to apply your mind on that aspect. And if you are filing any application, that you must put under what provision of law you are making. You are filing exemption application. You are filing some applications for directions. What provision? See, it is not sufficient to say in the Supreme Court. Most of the people say yes, application for direction, but under what provision? Nothing is inherent power. Even if there is an inherent power, there must be some source to any power, any application which you are making. You're filing a 32 petition, you write there's a petition under Article 32 of the Constitution. And for what purpose, for what writ, for what thing? It must be very clear to as you will be doing it for the court, when the judges read it, what the judges look for you. That if it is a writ petition, your prayer must be very, very clear. If it is an SLP, your grounds must be very clear, not repetitive, and of the similar sort. So what I'm highlighting, and again, you have, as I said, one important thing is what I find is from my colleagues on the last examinations have been students who have been appearing that they are not able to complete the paper. Now you have 100 marks and you have 180 minutes. Please divide it, because you will have 4 questions, 3 questions, or whatever it is. Suppose one question is of 40 marks. How much you divide it? That all right, I'll complete it in 60 minutes. You have 180 minutes total. If the question is of 30 marks, you have it completed in 45 minutes. Because many times I find that you are not able to complete, though you may know it, because in the first question itself, you exhaust your time more than what is required. Time management, whether as a counsel in the arguing in the court and more particularly in an examination, is very important. You must answer whatever number of questions you are asked to answer. And there the time management comes. Why I'm saying repeatedly, suppose there are earlier last few years questions I've seen, sometimes you are asked to write 4 questions, sometimes 5, sometimes 6. Suppose it is 5, then 20 marks each. Suppose it is 20 marks each. Then devote 30 minutes for one questions. Suppose it is 40 marks, then you devote 1 hour for that, because the examiner will be seeing on that basis. It is a drafting paper and your answer has to be commensurate with the marks for the questions are carrying. And leave some spare time, because sometimes you may overspend it, because toward the end you find that no, I haven't got sufficient time to answer. Let me complete it within 2 pages, half a page, or 1 page and attempt. But one strong advice would be that attempt all the questions you are asked. See the questions which you are being various sections which you are various sections which are there. See also what the question is, because sometimes the questions are very tricky. I found that the questions are very, and in 1 or 2 years, I find that the questions are without any facts. You have to be on facts when you make a pleading. This is the pleading in the court. In the SLP, we find that you go to the point directly, but no point can be made without facts. So when you draft, be focused on the facts, very clear on facts, very precise on grounds. Don't repeat any questions or any grounds or any questions. Don't try to sidetrack, because all of us would be, because you are stepping into an important aspect, important institution of the Supreme Court, an advocate on record, which is a prestigious thing for any one of us. That's why there is such an examination is being conducted. You must know what to write, what not to write again, because, and I always believe, come straight, come very methodical, to the point, focused. And I'm repeating again, read the question papers very, very meticulously. I'll hand it over to my friend, Mr. Savla, who, if necessary, I'll come back again and we will have the questions from you toward the end. But I have very few things to say in the introductory note, and which I have shared with you. You can ask me questions by the chat things, and my friend, Mr. Savla, will tell you in detail what all need to be looked into. Thank you.
Thank you very much, Hansaria sir, for your valuable inputs. I'm sure the participants would be delighted to hear you. Well, I would be very brief. I feel that drafting in Supreme Court is a bit different than drafting in District Court or High Court. Because drafting in Supreme Court is mix of both. We have to draft facts as well as question of law, and the authorities also we draft many times in the petition and in counter affidavit. So it's a very unique drafting which we have to consider. Now I have divided drafting topic into 5 heads. And why I have divided into 5 heads? Because that is the different jurisdiction Supreme Court exercises. So the first head, according to me, is the appellate jurisdiction. So the drafting for appellate jurisdiction is different, and I'll discuss that in a while. The second head is the original jurisdiction. The drafting for original jurisdiction also would be different. The third head would be review or curative petitions. The fourth, according to me, are the counter affidavits or reply which are required to be filed. And the fifth head would be various applications which we file from time to time. Now coming back to the first head, which is the appellate jurisdiction which the Supreme Court exercises, I would subdivide the appellate jurisdiction into the under Article 132 and 133, where the appeals would come to Supreme Court. When High Court gives a certificate under Article 134A that the question of law or the issue is of great importance and that should be decided by the Supreme Court. So when High Court gives a certificate, an appeal would lie as a matter of right under Article 132 and 133 of the Constitution of India. Under Article 134, there is a criminal appeal. If High Court reverses an order of acquittal and punishes the accused to death, then under Article 134, there is a criminal appeal, not SLP. There are a separate act enacted, which you all should know, which is Supreme Court Enlargement of Criminal Appellate Jurisdiction, 1970. Supreme Court Enlargement of Criminal Appellate Jurisdiction. Under this act, if the High Court reverses an acquittal and convicts an accused of an imprisonment of 10 years or more, or life imprisonment, again, it would be a criminal appeal, not an SLP. There are other appeals which are filed in Supreme Court, which are statutory appeals. The statutory appeals are under various statutes. As you know, the
योर एग्जामिनेशन को जब खुद ही बनाना था तो हमें के लूप में ले रहे हैं, फिर ये खुद ही कर लेते सारा.
Am I audible?
हेलो जी.
Yes, Mr. Savla, you're audible.
Okay.
Yes.
Okay. I thought the screen changed. All right. Sorry.
Yeah.
So third type of appeals are statutory appeals. So various acts we would have noticed which provides for direct appeals. For example, we will have IBC, Insolvency Bankruptcy Code, where a direct appeal is provided to Supreme Court. Similarly, under the Consumer Protection Act, if the NCADRC, that is National Commission, if it is exercising original jurisdiction, then the direct appeal will come to Supreme Court. Now, all these appeals have a different format than the SLP. In the appeals, you have to state the facts. Unlike in SLP, you don't state the facts. In the body of appeal, you have to state the facts. In the body of appeal, you have to mention the annexures. There could be a separate interim application or a separate stay application as far as appeals are concerned. Whereas in special petition, the interim application or stay is within the SLP itself. There would be no certificate required in cases of appeals of an AOR, which is required, as my friend pointed out, in case of an SLP. So these are various appellate jurisdiction exercised by the Supreme Court. The very important and the last appellate jurisdiction, which is most frequently used, is special leave to appeal under Article 136. And kindly note, under 136, a special leave to appeal can be filed against any order, judgment of any court. Even from district court, one can come to Supreme Court. From any tribunal, directly one can come to Supreme Court. Of course, if the case so requires. The only exception is if the order and judgment is passed by the court or tribunal under the armed forces. Under Article 136, sub-article 2, there is an exception. Barring that, every and any order can be tested directly in Supreme Court. If the merits of the case so requires, then direct SLP can also be filed. The format of SLP, as my friend Mr. Ansariya ji has already pointed out, is in Supreme Court rules. But just to emphasize that there are declarations required in SLP which you must remember. There are 2 declarations required within the SLP, and there would be a certificate of advocate on record which would state that no new facts are stated in SLP which were not pleaded in the court below, and no new documents are filed which were not filed before the court below. This affidavit, I'm not sure whether is in any rules, but by way of a practice guidelines, is mandatory now to be filed with a special petition. So these are various appellate jurisdiction which are often exercised when we file petitions or appeals. Now let me discuss the original jurisdiction, which is exercised by Supreme Court. We will file original suits under Article 131. Now, when is the original suit filed? Original suits are filed only if the dispute is between government and a state government and central government, or government or between 2 state authorities, and the issue is of great public importance. Only in such case, a suit will be filed on the original side under Article 131 of Constitution of India. The other original jurisdiction, which is exercised by the Supreme Court, are writ petitions. If there is an infraction of a fundamental right, or if you want enforcement of a fundamental right, under Article 32, a writ petition would be filed directly in Supreme Court of India. Again, public interest litigation has evolved over a period of time, which is also filed under Article 32 of Constitution of India. Now, if you were to draft a public interest litigation, you must remember a Supreme Court rule, and I will just point out the rule. It is under Order 38, Rule 12, which has some mandatory requirement. Under this rule, the petitioner has to state his full details and he has to file an affidavit that there is no personal gain, private motive, or oblique reason in filing of this public interest litigation. This affidavit is a must. If the court finds that your petition is vexatious or frivolous, then exemplary cause can be imposed. When you draft a writ petition, again, the facts would be stated in the petition. The annexures would be in the petition, not in the list of dates as we require in special petition. The other category of original jurisdiction would be transfer petitions. We have transfer petitions under Section 25 of CPC, where a civil proceedings can be transferred from one state to another state, not within the state. One state to another state, then direct transfer petition in Supreme Court under Section 25 of Code of Civil Procedure. Similarly, if you want transfer of criminal proceedings from one state to another state, it will be under Section 406 of Code of Criminal Procedure. There is third transfer petitions, third category, which is exercised under Article 139 capital A of the Constitution. Under this article, a Supreme Court can itself call the petitions, various petitions, to Supreme Court to decide the issue effectively. Under 139A, there are certain rules by Supreme Court rules which require an advocate to also give a certificate that the petition involves important question of law. Please examine these certificates because these are very mandatory certificates required when you draft a transfer petition under 139A of the Constitution of India. So these are the original jurisdiction which the Supreme Court exercises. Now let me touch upon the third category of drafting, which is review and curative petitions. You must be knowing that more than 99% of the review petitions are dismissed in chamber. There is no open court hearing given in review petition. Therefore, if you were to draft a review, in my view, it should not be more than 2 pages. And highlight what is the error apparent in a polite way to the court. Curative petition is again an exception. And you all must be knowing, recently Supreme Court exercised the curative petition also in a commercial dispute. So the powers of curative petitions are very wide. And so these are the review and curative petition, which are a different category in my view. The fourth category of the drafting would be counter affidavit or reply. Now, as far as I know, I was an advocate of record for almost 20 years. There is no fixed format for counter affidavit. Either you can have counter affidavit and deponent within the counter affidavit, or you can have a reply and an affidavit in support of the reply. So both are accepted by the registry is what I understand. However,
Mr. Savla, just a minute. Mr. Registrar, somebody is speaking on phone. It is audible to us. Please unmute. Please mute everyone except Mr. Savla. There are many people talking on phone and we can hear. This disturbs us and disturbs other students. Sorry, because I was hearing
Thank
many
you. Thank
voices
you.
from various people talking on phone, and they're supposed to mute everyone except the speaker.
Should I continue?
Yes, please do that now, because sorry to interrupt. Please continue.
Yes, thank you, Vijay. Should I continue?
Yes, please. Yes, please.
Yes, thank you. So there is no fixed format of counter affidavit. However, remember one thing, whether it is a counter affidavit or a reply, there has to be a statement or a declaration that no new facts are stated in your affidavit, which were not part of the record of the court below. The fifth category of drafting, I would categorize as various applications. And those are very important applications. As Hansarya sir pointed out, there can be an application for condonation of delay. There can be application to take additional document on record on the civil jurisdiction. On the criminal jurisdiction, there can be an application for bail, application for exemption from surrender, application for suspension of sentence. All these applications are again supported by an affidavit. So please, when you are studying, do pay importance and attention to various applications which are filed from time to time. Now, these are, according to me, 5 broad categories of drafting, which I have categorized based on the jurisdiction exercised by the Supreme Court. Now, what is expected from the candidates, from the students, when you draft a paper? According to me, your draft should be concise. It should not be repetitive. It should not be lengthy, nor should it use very fancy words. We have to keep in mind what a judge expects from us. When the Honorable Supreme Court judges have 60 to 70 matters on admission day, considering the pressure of work, we have to ensure that our draft is bullet points are stated in the synopsis. The questions of law, maybe 1 or 2 questions of law, can also be put in the synopsis. The draft should not be too lengthy. Let us take, for example, if we were to draft a special leave petition for bail, I would expect in a synopsis, you would put these basic facts as to what is the nature of offense, what is the provision under the FIR, what is the sentence or incarceration the accused has undergone, whether the co-accused have been enlarged on bail, what is the stage of the case, whether the charge sheet is filed. These are the basic things you would state in synopsis, because the honorable judges would prefer to read synopsis and not your detailed petition. Then, if you were to draft a question of law, let me give you an example. Supposing a contractor and a government company has a contract. The contractor has completed the construction. The government company has admitted that the amount is due in some correspondence and yet refuses to pay. The contractor files a writ petition in High Court. The High Court allows the writ petition. The company wants to come in by way of an SLP. So what is the question of law which will be drafted? Possibly we can say that the High Court should have exercised self-restraint when deciding petition under 226. High Court ought not to have passed order for enforcement of contractual rights in a writ jurisdiction. Now take a converse case. Supposing High Court would have dismissed the petition and the contractor wants to file a special petition, what would be the question of law you would consider? Probably you will say that though there is an alternate remedy, civil remedy, but that's not efficacious alternate remedy. The question of law could be that the government company is bound to act in a transparent manner, and any decision should be rational decision. If the act of the government company is on the touchstone of Article 14, not sustainable, then the High Court order requires consideration. Take another case. For example, a purely civil dispute, a civil suit is filed, and for the same transaction, an FIR or a private complaint is filed under CRPC. You go for quashing after summoning order is issued. High Court refuses to quash your petition, despite the fact that it's a predominantly civil dispute. What would be your question of law? Possibly that the High Court has ignored the well-settled principles laid down by the Supreme Court, starting from Bhajan Lal, and from time to time, that the criminal mechanism or a machinery should not be utilized for the purpose of vested interest. These kind of questions of law can be put forward and would be helpful. Now, let me give a broad background of what paper can be expected as far as drafting is concerned. There would be a long question, probably of 40 marks, which is not too sure, but subject to the committee confirming. And there would be 3 short questions. Please divide your time, as Ansari has pointed out, so that no question is missed out. We were informed on the previous years that the paper was quite lengthy. And though half an hour extra time is provided, they found paper to be quite lengthy. Please read the question paper carefully, because in the short questions, you would be only asked to draft either list of dates, synopsis, or question of law. Then kindly only confine to what is asked. Or you would be asked to draft only this SLP without list of dates or without synopsis. In that case, you have to only draft questions of law and grounds and the required declaration, etc. So kindly read the question carefully and only answer what is stated in the question. The question would be self-speaking. Question will say whether affidavit is required, whether index is required, whether synopses are required, whether list of dates are required or not. Whatever is specifically asked, you kindly only attend that part. I would also suggest one more thing. We have still about, I think, a month for the exam to be scheduled. And since on the last couple of years, the paper was found to be lengthy, one way to deal with it is take out one question every day and start attempting one question. The question papers are already circulated and they are also available on Supreme Court website. Take out any one question every day. Write answer, show it to your senior or to your colleague, or see yourself whether you have answered correctly or not, after checking the law and after checking the question paper correctly. This will increase your speed and will also give you confidence when you go to attend the paper. I think with these words, I would like, if there are any questions or queries, I would be happy to answer with Mr. Ansaria, sir.
Yeah. I think Mr. Savla has almost covered everything hardly and given you a sufficient indication as to how to you proceed to answer the questions. One thing I would like to just add, when you are drafting SLP, what are you annexing? For example, in a civil proceedings, I would expect the original proceedings, that is a plain written statement, or if it is a writ petition, the writ petition and the counter affidavit must be annexed. Original pleadings are very important. The appellate pleadings you may not annex. Suppose it's second appeal, you may not annex the first appeal, you may not annex the second appeal, but you must annex these plain and the written statement and the important witnesses. Similarly, Mr. Savla has told you that in a criminal case, you must start from the FIR because that is the originate, the criminal proceedings. The FIR, then you must say what are the prosecution witnesses important. Suppose there are 50 prosecution witnesses. You don't go on annexing everything. The eyewitnesses, the medical, or so if it is circumstantial, the main witnesses on which the conviction is sustained. You must say that yes, a true copy is annexed and marked as so and so annexure. So that will be in your index, that will be in your list of dates also. And you must see there, because there are 4 or 5 provisions in the Supreme Court rules which says what to, as Mr. Savla has told you that that for a PIL, there is an Order 38, Rule 12 says what all you need necessary by way of statutory rule. If you don't do it, your petition will not be entertained. It will be lodged by the registrar himself. It will not go to the court. So don't file a writ petition or a PIL which does not meet the parameters, and it goes to the registrar himself. Nowadays, I found that there are so many PIL which are registrar himself is rejecting it, and rightfully so. If you don't comply with the minimum things, then it gets rejected. So there, Order 21, let me search 4 or 5 orders I would like you to note. Order 21 rule deals with civil SLP, especially Rule 3 deals with what all you should say and what order you should say. Order 22 rule deals with criminal SLP, which said it will be the same format as civil SLP. Order 38 rule 1 deals with 1 to 10 deals with writ petitions, various writ petitions. Order 38 rule 12 deals with PIL, as we have already told you. Order 39 rule deals with transfer petition criminal, that is 406 CRPC. I'm sorry, Order 39, yes, right. Order 40 deals with transfer petition 139 capital A, and 139 capital has 2 parts. Part 139 capital A 1 and 139 capital A 2. So please make a note that 139 capital A 1 is for substantial questions of law, and all Order 40 and 139 A capital A 2 is that High Court, the Supreme Court in its, if it expedient in the interjustice, transfer one to another, one High Court to another. It's similar to Section 25 CPC. That's why Order 41 of Supreme Court rules brackets the requirement of the transfer petitions 139 capital A2 and Section 25 CPC. They are bracketed together. They are similar, expedient in the interest of justice, very wide terms. So all these provisions you must very carefully know it, and don't sidetrack. Don't try to say that all right, we have written 20 pages, as Mr. Savla has also been saying, that you seeing that you've written 40 pages, 50 pages, 60 pages, and will get marks. No, you will get more marks, but you should be more focused, more more specific. Don't try to bulldoze anyone. Sometimes we do it in court, but then don't think that exam, and especially you won't have an opportunity. What we read, what point of time, if it is neat, methodical, it impresses us. If it is not neat and methodical, should be there. All right, now we'll answer some of the questions. One question is how many questions of law and how many grounds should be there? See, it all depends on, as you are having, we need to know that whether you have understood or not. Maybe 2 or 3 questions of law, 5, 6, 7 grounds, and not more than that. Any Supreme Court has already only 1 ground or 1 question of law on which they entertain. But if it has 2 or 3, I think that will be sufficient. If it has 4 or 5 grounds, I think that will be sufficient. If you have questions, we will go on answering the questions. We do it. Now, somebody has asked about So
Yes.
annexure of the annexure. So you have to mention in the list of dates you annex. You don't have the documents to annex. You are in the list of dates you annex. And if you find that from the questions, some documents are not on record, then you say that, all right, separate application is filed, seeking permission to file additional documents. Yes. I think slowly that questions are, there are too many questions.
Yes, I'm not able to actually read the
Yes.
question. They're running very fast. Let me check.
Draft listing pro forma. Yes, there are certain listing pro forma. Supreme Court, if you ask to file, that depends. That's what again depends on the questions. If you say that make a complete list SLP, complete SLP is complete SLP as you would file in the Supreme Court, which will include right from the cover page to the index to the listing pro forma and so on. So read your question paper carefully. Yes, somebody asked whether you should mention leading cases. Yes, if you know on the subject any leading case, of course we do know, and that's why you score additional marks also. But
And that is why we say Supreme Court drafting is a hybrid drafting. You have to state facts as well as law. You
Yes.
can draft both.
yes, not necessary to give exact citation. If you can give the approximate year or the cause title, that will be sufficient, because nobody would expected you to remember the exact citation. I think somebody is asking what is the procedure for giving the marks. That is, you have to leave it to us.
Only hint I can give is there would be some options given. and all of you will find questions very interesting.
Yeah.
Do keep yourself updated with these laws, because that will help not only in drafting paper, in our overall development, as well as in leading cases. So do keep yourself updated whenever you get time to read all the judgments, leading judgments.
Yes, somebody is asking whether we have options. Of course, I think I would expect, yes, there would be options.
Yes, there will
And,
be sufficient options. Nobody
yes,
would
you
be
will-
left unhappy. Yes.
You will have options, but then again, don't answer. Suppose you are asked to answer one of them, and you answer both of them. Then again, you are asked to answer.
I have
two of
doubt
them.
they will have so much time.
Yes. So be
Yes.
very careful with the question paper. All right. Somebody is again asking how many grounds. Again, we cannot say how many grounds, but then I would think that 4 or 5, because with the time constraints you have, depending on the marks which you required. If the question asks that only ground, draft only ground, then it may be little elaborate. If the question is that if it is complete SLP, that can be little. If the question is that only
Yes.
synopsis, then there will be no ground. So it all depends. You have to take that.
Read the question carefully and thoroughly. Question itself will give you some grounds, and we would also be providing the relevant statutory provision with the question. So if you read questions 1 or 2 times thoroughly, that itself will give you what are the challenge one should make.
I think questions are there are too
Vijay
many.
sir, are you able to read the questions? Because
Yeah, they're changing it very, very fast. So because
the original should, I think the
I don't know,
formats are all given in the
Mr.
Supreme Court
Registrar, is
rules.
there any way that the question can remain on the screen for a little while? Because the questions are changing every 2 seconds, so we're not able to read any questions as such.
I think somebody is asking to share the sample questions, but there are various groups which are formed, I'm told, by the aspiring advocate on record. They must contact those groups, and they are sharing most of the drafts, I'm told. So they can contact their friends, and I'm sure the drafts can be exchanged.
Somebody asking recording. I think yes, recording is available, and it can be. You can hear us again by doing this.
But do practice drafting. every day, one question a day for a month. No recording is required again.
Yes. As Mr. Savla has told you that you should try. Somebody is saying sample papers you have for last 10 years on website. So you go on answering those questions. Because if again, to be scientific, take question, answer them, whether you are able to know, and time management. Time management is very important, especially in this paper. I have seen it. Time management is not there because I find the candidates last 2 years are last दो question था मेरा छूट गया. So उसमें then what can the examiners help you? Will not be able to help you.
There is a question asked, I think, a couple of times on 40-mark question. So we can only say there is a question which will be a long question, probably 40 marks, not very clear yet, because it's the committee who has to finalize it. And there would be short questions. As far as long question is concerned, we would expect a comprehensive draft from the start till the end. Can somebody splash something? Election petition?
Somebody said, can you guide us on 40 marks? And again, Mr. Savla is saying 40 marks, if it is there, then it must be maybe there's a complete thing. And if it is shorter question, then it would be ask a part of it. Suppose a certificate, only the grounds, only the synopsis, or only the format, or only the requirement of a PIL or something of that sort.
So the election petition will be, copy can be taken or a draft can be taken from the group, I think. And also they would be available in Supreme Court rules. Computer, unfortunately, the screen is running too fast.
Yes, it's going too fast. Yes, it is going fast. Again, the computers, again, something is there. There will be computers. Again, yes, I think the registry has sufficiently informed you that there will be a computer where it will be done. You will get the computers. We will be made friendly with them. There will be those who have opted for answering on the computers. But then once you have opted, you cannot change it in between. You will have to will be only allowed to answer in that mechanism only. But
there
slowly.
Sorry, sir. Sorry.
Yes, please, Ken.
There was a question. Is there a mandatory question asked? Now, whether mandatory or not mandatory, I'm sure the questions are very interesting, and all of you would be able to answer it.
That's why we started saying that read the question paper. If it is mandatory, it is mandatory. If it is optional, optional. But then you will have options. Let we make it clear. But then, and at the beginning, please, if it is optional, make it how many sections it has and which section, how many questions you are required to answer. Make that made up that mind. Again, I'm repeating. We have seen it earlier. In one section, you are asked 2 questions, but then only out of 4, then end up answering 3 questions. So one question, the last question, which may be the best answer of your will attract will get only 0 marks. So see that what is required.
All right, I think we have. I hope today's lecture was useful, and we wish all the best to all the candidates. Vijayji, any other issues?
I think that is sufficient for us, and yes, and you have hectic schedule ahead, including the elections which are coming up in the Supreme Court Bar Association, and I find that you have this lectures morning, afternoon, also more than one in one day. So be very careful and take this examination as a very serious examination. It's a milestone for all of us who entered this profession to become an advocate in the court of the Supreme Court. And
as I said earlier, have a good speed. Don't miss out on any question. Attempt what is asked. Okay, thank you very much.
Yeah, wish you all the best, everyone.
Wish you all the best.
Thank you.